So good afternoon, welcome to the 2012 TARGETjobs National Pupillage Fair and to this public law talk. Delighted to introduce your speakers for today. We have Jeremy Johnson QC in the middle there from 5 Essex Court. On the left we have Alex Goodman for 4 to 5 Gray's Inn, and here we have Joe Barrett from 11 KBW. Okay, they will be talking to you today about public law, sort of spending about 5 to 10 minutes each talking about why they chose this area of law and what they really think the key qualities are associated with this area. Please do hold any questions that you do have until the end. I will open the floor to any questions then. So just hold off. If we could also turn off phones because it does interfere with the camera equipment. The reason why we have this is because obviously in previous years the talks have been very popular, and this does mean that certain students are disappointed if they don't get to see or hear the talks. We are therefore recording it. This is going to be available online from Monday morning, so any talks you wanted to see and haven't been able to, or if you just want to recap this one, please do go online to either our website or our YouTube channel and it'll be on there. Okay, so Jeremy, if you would mind going first.
Thank you. My name's Jeremy Johnson and I'm a barrister at 5 Essex Court, which is a chambers that specialises in public law generally, but is particularly known for police law within public law. I want you to imagine I'm giving this talk with great passion and enthusiasm and verve. Unfortunately, I've been struck down with what my wife uncharitably calls man flu, which is why Alex and Joe are keeping their distance and why it might be a bit subdued. So imagine away the subdued nature of the talk and imagine it's being given with great passion. I'm afraid I, at your stage, probably didn't know much about public law. I'd certainly never seen a judicial review claim. And other than having studied it on what was then called the CPE course academically, I really didn't know what it was like in practice. And I certainly didn't have any burning desire to practice in public law. It's pretty unimpressive, I'm afraid, but I made decisions on pupillage applications, not so much on the narrow area of law that particular chambers practiced in. But on some other broader factors. They included, for example, the number of pupils that chambers took each year, and perhaps counterintuitively, I was very keen to go to a chambers which had very few pupils. It meant it's much harder to get pupillage, but if you do get pupillage, if you choose your chambers carefully, where they take few pupils each year but give tenancies regularly, then it means that you've got over pretty much 2 hurdles in one go. So that was one of the criteria. The other was I wanted to go to a chambers where I thought I would get on with the other members of chambers, and there was a good atmosphere in chambers. I suspect most of you have done mini pupillages, and you will know that chambers vary a great deal in the atmosphere amongst members of chambers, and obviously different atmospheres will be congenial to different people. And the third criterion was really I wanted to go to a chambers that did a relatively wide area of practice. Although, as I said, 5 Essex Court is principally known for police law, within that there is quite a broad variety of work, including classic public law, which I'll mention in a moment, but also civil actions against the police, personal injury actions, employment, and so on. The sorts of cases I do in practice are classic judicial review claims, principally, as I say, challenges to police conduct. So, for example, I've acted in cases where the police are challenged over the way in which they police public order demonstrations, the way in which they take photographs of protesters and retain photographs, DNA retention, kettling, stop and search, the disproportionality between the racial backgrounds of those who are stopped and searched, the full range of public law challenges, but within a police context. But there's also wider public law type work we undertake. That would include, for example, public inquiries. So members of chambers are currently acting in Leveson and in the past have acted in the Hutton inquiry into the death of Dr. David Kelly. the Macpherson inquiry, and a range of inquiries in Northern Ireland. But it also involves, and some of the most interesting work is the non-contentious policy advisory work. So, for example, advising the police. Recently I've advised the police in relation to their Operation Elvedon, which is the operation into corruption between journalists and the police, and the strategies they've adopted in that case, counter-terrorist operations, restructuring of the police nationally. And it means one is engaged with the client before cases even become litigious. And as I say, there's also a broad range of employment law work and personal injury work. What I particularly like about public law, it always feels a bit pompous if one starts trying to analyse what it is one likes about it. I do very much enjoy the work in chambers. I do find it enormously fulfilling. I think if one had to analyse what I find attractive about it, it would be things like the mix of policy and law and fact that one gets in most cases, the pretty high profile nature of the work, the fact that it's often at the cutting edge of the development of both public law and common law principles, and also that there's a lack of the sort of sterile, arid procedural scraps one has in normal common law litigation. Judicial reviews tend to proceed at a relatively civilised manner. There's standard directions that usually people comply with, and one doesn't have the last-minute brief the night before, which one has to get up ready for a hearing the following day. It's a pretty civilised pace of life. Shall I hand over to Alex, who'll give another presentation?
Hello, my name's Alex Goodman, and I'm a barrister at 4-5 Gray's Inn Square. 4-5 Gray's Inn Square is a chambers which practices predominantly in public law, comprising community care, education, immigration, and with a strong emphasis on planning and environmental law. My personal practice is split largely between planning and environmental law related judicial review and cases connected to immigration law. But I also have a number of more arcane areas that come through chambers, such as election law, village greens, footpaths and so on. I work almost exclusively on behalf of claimants, in other words, for the individual against an emanation of the state, whether it be a local authority or central government. And I think that's really where, when I set out, I wanted to get to. I've been practicing now for 8 or 9 years, and I'm sort of content with where I am, but it's been quite a sort of difficult path to get there, and I thought perhaps what might be helpful for those of you entering into public law at this early stage would be to set out some of my experiences, and really to stress that there are a number of ways in which one can, in the end, build a practice in public law at the bar, even if you don't make it through the very direct route of a pupillage straight into a tenancy at one of the top public law sets. So I think I'll just start at the beginning. Really, my motivation for entering into the bar was to practice public law. I wanted to do something which contributed to society and to act on behalf of people who came from disadvantaged backgrounds, and to help or contribute to society in that way. And so law of itself wasn't particularly interesting to me. I had looked at other fields which potentially gave effect to that aspiration. I'd looked at working in rehab centres for drug addicts and so on, but it felt like law presented the intellectual challenges that I felt like I needed. And so coming from that perspective, the legal establishment, the legal world was really a considerable shock to me, because that is not an outlook that is shared certainly by the majority, and that outlook I would say is probably looked down upon and sneered at by a significant minority of those at the bar. And I think this translated into a certain amount of naivety and difficulty with accommodating myself to what was expected of me. I did manage to get a pupillage first time round. I certainly, in retrospect, realised that my old pass application, which I imagine you're all working on, or whatever it's called now, for pupillage, was very poorly set out. I applied both for criminal sets and public law sets, and then your personal statement becomes rather unfocused when you have that sort of range of chambers that you're trying to direct yourself towards. And I didn't get very many interviews, so I was quite lucky to get a pupillage, and I took the offer. And the set I went to was a very, very ambitious, hard-working, a very high-quality set, and I wasn't ready for it. I was just out of bar school. I'd been a student for the best part of my adult life, and I didn't work hard enough. I really wasn't ready for the ambitious culture, and I didn't get taken on there. And so at that stage, my chances really of ever getting back into the bar are probably quite significantly diminished, but fortunately I managed to get what's called a third six pupillage, where you get another go for 6 months at another set. Unfortunately, that set proved to be completely incompatible with what I wanted. It was a very, very traditional set. There were only 2 women out of 50 members of chambers. Virtually all of them were boarding school, Church of England kind of background. Had to have lunch every day and discuss matters such as farming and ecclesiastical law, and I really didn't get on at all there. I mean, one day I turned up without a tie, and by lunchtime the looks that I'd had driven me to find a suit shop to make sure the afternoon didn't go so badly. So that didn't go very well, but fortunately a very small set then I applied to, that was just starting up, had advertised, and I applied to join there as a tenant, and they took me on, took a gamble on me, and for a couple of years I practiced there and managed to build up a practice in immigration law and in planning law through a number of charities and organisations I'd been involved with outside the legal world. So I'd done bail applications for immigration detainees, and I'd done work for environmental charities, and so that kind of work that I was interested in started to build up at that chambers, and eventually I then worked on a case with a silk from 45 Grazing Square, where I am now, and he invited me to apply, and that ultimately resulted in me being taken on there. So it took me probably 4 years to get to somewhere where I could build the kind of practice that I'd hoped for. So I think that the point of that long sort of way round is to, as I said at the beginning, really to stress that you don't have to go straight through pupillage to tenancy and into practice. And in actual fact, the struggles that I had on the way, I think, have meant that I ended up building a practice that much more fitted what I wanted to do, rather than just being given cases by chambers and had them laid out on a plate for me. I've had to work much more to develop my own field. And when you look at the people who practice, certainly on the claimant side of public law, there is quite a divide between people who represent the state and represent the individual. But on that side, they often come from having had experiences in other fields for considerable periods of time, whether working as a solicitor or working in charitable organisations or political organisations first, and they bring that experience of society in the real world into their legal practice. So I think it is an extremely difficult area to get into, and you have to be aware of that. But I really want to pass on the message not to be disheartened by the difficulties you'll encounter in getting pupillage and getting tenancy, and that there are opportunities along the way to get back into the bar, and I do recommend that to all of you, provided you've got the ambition and the willingness to work hard enough to succeed.
Alex?
Hello, I'm Joe Barrett. I'm a tenant practicing in public law at 11 Kingsbench Walk. We're one of the leading public law sets, and we practice in almost all areas of public law, with the exception really of planning, which is interesting. Alex mentioned it's one of his areas. As a chambers, we've collectively decided I think it's not something we find particularly interesting. but I'm sure Alex may have a different view on that, perhaps discussed towards the end of today's talk. I should say that about 70% of my time to date has been spent working on public law issues. However, I also do quite a significant amount of work in employment law and commercial law. One of the things you'll be aware of, or will discover in due course, I'm sure, is that there's really no set of chambers that I'm aware of which practices exclusively in public law. And certainly as a junior practitioner, the reality of your practice will be that you'll do a very wide variety of stuff. One of the things that you guys perhaps should be thinking about at this stage is what other areas of law, what other types of practice you might like to combine or overlap with public law, if that's your principal interest. I finished pupillage in early October of last year, and have only been in practice as a tenant now for around 5 months. So for today's discussion, I think I'm the representative of the very junior end of the bar. Why did I choose to come and be a barrister? I'm probably something of a sad case. I studied law as an undergraduate, Scots law in fact, at the University of Glasgow. I went off to the States to do a master's again in law. Probably take two things from that. One is I have a lack of imagination. Two is that I enjoyed working with and studying law. Both are true. When I speak to my friends who've gone off to do other things, some are investment bankers, some work with large firms of solicitors, it can sometimes feel as if you're confessing to a slightly dirty secret when you say that you actually enjoy your job and fundamentally enjoy your daily work. But there we are. I do, and I think in a nutshell that's why I've come to the bar. In terms of public law, why choose that as your area of focus? In my opinion, it's by some distance the most interesting area to work at the bar at the present moment. Public law, as we all know, essentially is about what the state can or can't do to individuals in a variety of contexts. It's not politics, but it's politics by other means, you might say. Certainly there's an inescapably political dimension to the work you do. If you're the type of person who is interested in how we're governed, how society works, what rights people should or shouldn't have, you're going to enjoy it. You're going to find it very, very stimulating. Another reason I was attracted to public law is just the sheer range and variety of the fields and types of issues to which it gives you access. By way of illustration, my chambers covers human rights law, administrative law, freedom of information, data protection, EU law, immigration, asylum. A short talk like this, it's not really possible to give any sort of comprehensive account of how those fit together and what the relationship is between them. But I thought what might be helpful, just to give you a flavour, is just to give you some examples of cases I saw during pupillage or since I've become a tenant. So I worked on Green and MT against the United Kingdom. This is a case in the European Court of Human Rights in Strasbourg, which is about essentially whether prisoners should have the right to vote, whether UK law which deprives them of that right is compatible with the Convention. The Building Schools for the Future litigation. Did Michael Gove, the Secretary of State for Education, act unlawfully when he cancelled the old Labour government's capital project scheme for funding and building new schools? This was not a case about human rights, a case about domestic judicial review and public law principles. Shoesmith against the Secretary of State for Education. Did Ed Balls act in a manner that was contrary to natural justice when he effectively removed Sharon Shoesmith following the Baby P tragedy? Again, not a human rights case, very much based on domestic law principles. Joint Council of Welfare Immigrants against the Secretary of State for the Home Department. Did Theresa May act beyond her legal powers when she implemented the coalition government's cap on immigration following the election? Again, another domestic law case. Since commencing practice as a tenant, one of my first cases and one of my most interesting cases is one called Bruton against the Information Commissioner in the Duchy of Cornwall. And this is a case about whether Prince Charles and his Duchy of Cornwall should be regarded as a public authority under EU law, and particularly EU environmental law. I'm sure you may all have encountered Prince Charles publicly speaking and quite ardently pressing environmental issues in the public sphere. Interestingly, in this case, we discovered that he doesn't want environmental law to apply to his own activities or his own lands. in terms of what I find appealing about that area of practice, I think that summary of cases probably neatly encapsulates what it is I enjoy most. I think Jeremy's points very well made. You risk sounding absurd when you start waxing lyrical about why you enjoy it so much, but these issues are important. They're controversial, and there's no obvious correct answer to them. Having the chance to be involved in trying to work out the right answer is something which is both very, very interesting and very rewarding. One of the things we were asked to speak to was lifestyle implications of practicing in this area. The only obvious one which sprung to mind for me is the fact that because the cases tend to be very interesting and both, well, also I should say, relatively complex, there is a risk that you can find yourself being absorbed, very absorbed in your work, and that obviously poses the risk of repercussions for your personal life. I suspect that's something that if you're lucky enough to enjoy your job, you would probably encounter in any area of practice. But to date, that for me has probably been the most obvious or most pressing issue that I've had to wrestle with. I'm aware that in some areas of public law practice at the bar, certainly in the early stages, it can be, I think, relatively tough financially and also in terms of work stream. One obvious example, which Alex would be able to speak to well, would be immigration asylum. Certainly my friends who work in that area say that there's real pressure on rates, and that has implications for obviously your professional choices and everything else. What I would say is if you're lucky enough to get into one of the top public law sets, you're actually in a very privileged position, because I think that the reality is, even from day one, you're relatively well remunerated and you work within a very comfortable environment. And I think we're very fortunate in that respect. Key skills, I don't want to be presumptuous and sort of start issuing forth opinions about something I've been doing for 6 months. I think generally intellectual curiosity is a good thing, both about the law and the underlying issues to which you're applying it. The cases, as I said, can be very demanding, all-encompassing, and if you don't have that interest, an acute sense of curiosity, I think you'll struggle to deal with the challenges it poses. We're also asked to think about things that might be an impediment to progress in this area. One that occurred to me might sound slightly odd, but it's inflexibility of thought, both in terms of your approach to the law and wider suite of issues. I think public law is a very fast-moving and fluid area. One of the things I've been struck by, both in pupillage and even in tenancy already, is how often, how frequently the answer to a case comes from really scrutinising and really challenging something which has been an assumption or a sacred cow, whether that's a statute and its interpretation, or a dictum of a judge, or just how things are organised in practice. It's not good to finish on a very bad cliche, but you need to be able to think outside the box, I think. That's really all in terms of my prepared remarks. One point I would probably just pick up, I thought Jeremy made, which was very apposite, is numbers of pupillages and tenancies that the sets you're applying to. So this is just a general piece of advice, I guess. I think that's a really critical thing to think about. Look long and hard about the approach sets actually take to pupillage. Are they serious about retaining their own pupils, keeping them on board, or do the retention rates indicate that actually they have a rather more relaxed approach about whether you do or don't survive the pupillage year? That was something I thought very carefully about when I was applying.